Well, there is some news in the Jay-Z lawsuit, and you will recall that Jay-Z was named in a lawsuit filed by none other than Jane Doe. That's right. We don't know who this plaintiff is. Well, this plaintiff filing as Jane Doe sued Sean Diddy Combs and Jay-Z for extremely inappropriate conduct, to say the least. Well, Jay-Z now got himself an attorney, a very high-profile attorney. You may have heard of him. His name is Alex Spiro from a very high-profile firm. And this is the same attorney who represented Alec Baldwin and, in fact, got that case dismissed in the middle of trial based on a Brady/discovery violation. So this is an attorney who's very good, he's very smart, and he's got a very big team at these big firms. So Jay-Z hired this attorney, Alex Spiro, and Alex Spiro filed a motion in response to this lawsuit. So he didn't even answer the lawsuit. He filed a motion to dismiss this lawsuit and or to have the plaintiff be required to say who she is. She has to disclose who this plaintiff is. Now, generally speaking, you always have to say who you are. You can't just sue people anonymously, right? We have to know so we can confront whoever it is who's making these allegations. So that's generally true. Now, there are certain times when there are certain circumstances, certain factors that are present where a plaintiff is going to be allowed to proceed as Jane Doe anonymously. And this is exactly what they're arguing about. Now, we did a video on this. We already explained the different non-exhaustive factors, which simply mean that there's a whole bunch of different factors, like 10 factors that a judge can begin with. But it's non-exhaustive, which means that there's other factors. The judge can certainly take those other factors into account as well. So there's this list of factors, and basically both sides are going to be arguing about which of factors apply in this specific case and which favor do they go in? Do they go in favor of anonymity, or do they go in the favor of disclosure? So this is the argument essentially between, right now, Jay-Z, Alex Spiro, and the plaintiff, Jane Doe, and her attorney. So what happened is, right, this Alex Spiro filed this motion to this opposition to the motion that the plaintiff filed. So the plaintiff filed the motion, Alex Spiro filed in opposition to the motion, then he filed a bunch of other things, other letters and other motions. So this is in one order where the judge is taking care of everything that was filed. But the most important issue, obviously, is this issue, whether we're going to find out the name of this plaintiff, Jane Doe. That is the most important part. Now, the judge is also going to talk about the other motions, as well as she is going to really share her mind, give Alex Spiro a piece of her mind about how she feels about his posture that he is taking so far in this case. So it's going to be a pretty wild read. So here we go. I'm going to start off pretty standard, and we'll see where this goes. So this is the order right here. This is the opinion, as you see, the order. This was just filed December 26th, so just yesterday of the recording of this video. And here we go. You see the defendants, Sean Combs, and there you also see Sean Carter. Sean Carter is Jay-Z. So here we go. Plaintiff Jane Doe filed this action on October 20th, 2024, alleging violation of the New York City Victims of Gender-Motivated Violence Protection Act, etc. By order dated November 6th, 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. So at the very initial stages of this lawsuit, when there's been no even defendant who was appeared, no defense counsel, I mean, this was before Alex Spiro appeared on behalf of Jay-Z. It was just the plaintiff. The plaintiff filed this motion, and the judge said, fine, you can continue to proceed anonymously. But she said, the judge, that it may shift as the suit continues. Okay, well, let's see what happens. On December 8th, 2024, plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. Plaintiff again sought leave to proceed anonymously, but this time Carter's counsel, and throughout this entire opinion, she doesn't refer to who Carter's counsel is. I think that may be on purpose, because she doesn't want to name him, because she's about to reprimand him, to say the least. And therefore, maybe she doesn't want to say his exact name, but we know his name is Alex Spiro. Okay. So plaintiff again sought leave to proceed anonymously, but this time Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rules of Civil Procedure 12b1. And this is exactly what we went through in the previous video on this specific case. So if you haven't seen that, definitely go check that out. Carter also moved for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an associate. So this is a letter that Carter's attorney, Alex Spiro, was filing with the judge, with the court, which within that letter, it contains a declaration from an associate. So this is an associate's recounting of a phone conversation that this associate had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of sexual assault. Carter's lawyer asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegations against him. On December 13th, 2024, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. In the interview, plaintiff, speaking anonymously, so we didn't know who she was, explained her allegations against defendants and her reasons for coming forward now. Carter's lawyer points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff's claim have no factual basis whatsoever. And that's a direct quote from Alex Spiro's brief. He also argues that plaintiff's counsel violated Federal Rule of Civil Procedure 11B. Now, anytime you talk about Federal Rule of Civil Procedure 11B, all attorneys start to get very careful and very nervous. Why? Because that rule governs sanctions. Okay, so when you start citing Federal Rules of Civil Procedure 11B, no attorney appreciates when another attorney asks the court to sanction them. Okay, now here you have Alex Spiro saying that this plaintiff's complaint violates Federal Rule of Civil Procedure 11B by failing to undertake a reasonable inquiry into the facts before filing the complaint, which simply means that you can't just file complaints. If somebody walks into your office and you don't look at any documents, they just tell you something and you don't do any sort of research and you say, okay, let's go with it. Why not? Let's just file the lawsuit. That's not good enough. You got to do some sort of reasonable inquiry into the facts before you just file a lawsuit. And if you don't, then you could be sanctioned. Okay, you can't just file lawsuits and say, hey, if this turns out that this never happened, we'll just dismiss the lawsuit. No, you can't do that. You're making another person go through the expense of defending a lawsuit. You got to do a little bit of research, some reasonable inquiry into the facts before filing the complaint. So this is what Alex Spiro is claiming, that once you saw that interview on NBC News where the plaintiff herself acknowledges that there's inconsistencies in her story, well, then how can you file a lawsuit based on the plaintiff's facts or version of events when she herself acknowledges that there's inconsistencies? That's in violation of 11B. And therefore, perhaps the court should assess sanctions against plaintiff's attorney. All right. Failing to seek admission pro hac vice to this court. Also, the fact that he failed to seek admission. Carter's attorney requested an expedited briefing schedule for a motion to strike the First Amendment complaint under Federal Rules of Civil Procedure 11C2 and 12F. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F. Okay, so this is an emergency motion to preserve evidence, okay, and also to strike the amended complaint. So all these filings, Spiro is just filing motion after letter after brief and arguing things, right? So you can tell that right away. So motion to proceed anonymously. Now, this part of the order we're going to kind of skip because we already went through all the factors in our previous video, and there's a list of non-exhaustive factors that the judge is going to go through now and is going to weigh each factor, why this factor weighs in the favor of the plaintiff and this factor weighs in the plaintiff of the defendant, and she's going to go through it, and ultimately she's going to come to a conclusion. And since it's so technical of, all these factors weighing them, we're just going to skip this part, and I'm just going to tell you, suffice it to say, that she is going to grant the plaintiff's motion, at least at this point, to remain anonymous. So let's just go through to the end. As you see, these are all the different factors, which we already discussed in our previous video. And okay, so there's 10 non-exhaustive factors. And here she is weighing all the factors. Okay, and then we'll go to the end here where it says, accordingly, plaintiff's motion to proceed anonymously is granted. Plaintiff is advised that because the balance of these factors will certainly shift as this case proceeds, especially if and when the parties engage in discovery in earnest, the court intends to revisit this decision at a future date. Okay, so the judge is just saying, look, this is just a decision I'm making for now, but I'm going to leave open the opportunity for me, or the option for me, to revisit this and change my ruling at that point. Okay, but right now, this is her weighing of the factors, and she believes that the case should continue, at least at this point, at this juncture, with the plaintiff remaining anonymous. Okay, now this is where it gets to the juicy stuff. Remaining motions. Since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding on the purported urgency of this case. Okay, now you'll remember, as we went through this, Alex Spiro was not holding back any punches. He was accusing plaintiff's attorney Boosby of doing this just for his own publicity and promoting himself, and he said that very clearly. And he really, really attacked plaintiff's attorney. So let's see what the judge has to say about taking this posture. So here we go. Well, first she has to go through all the times that he did it. Okay, so describing plaintiff's counsel as self-promoting and accusing him of extortion, requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention, asserting that plaintiff's counsel seeks only to benefit himself, requesting the shortening of a deadline from 21 days to 1 day. Can you imagine? You normally have 21 days. We want to shorten it to 1 day. Describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys and requesting a hearing on a motion the following day. After levying that type of accusation against an attorney, how this is an attorney who's blatantly violating his ethical obligations, and he wants our hearing the next day on that. Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. Moreover, although Carter's attorney assails plaintiff's lawyer as having a chronic inability to follow the rules, and that's another allegation he made against plaintiff's counsel, that he has a chronic inability to even follow the basic rules of court. Well, guess what? The judge is going to say, you shouldn't be throwing rocks if you live in a glass house because you're guilty of the same thing. Carter's counsel has failed to abide by this court's clear rules. Under the court's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to the filing of any motion. Okay, you should know that. The court's individual practices. So what this means is that there's general court rules, right, which every court has, and then there's also individual practice rules, meaning that there's different courts have specific rules and judges have specific rules. So as a lawyer, you're not just supposed to look at the general court rules, but you also have to look at the individual practices of the court and the judge specifically, because they may have specifics that you got to follow, which can be very annoying. But nevertheless, if you want to practice in front of that judge, that's what you got to do. And this is where there's a requirement in the individual practices in civil cases that a pre-motion letter is required prior to the filing of any motion. And guess if Spiro did that? I guess not. Although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under Rule 12F, he did not give plaintiff the requisite 5 business days to respond. So you're supposed to give at least 5 business days to respond. You can't just have a hearing right away, or wait for the court to set a motion schedule, or state whether any exception to the court's individual practice is applied. That's what you have to do under the individual practice. You have to cite why there should be exceptions to the individual practice rules. Okay, this wasn't done. This is unacceptable. Now, a lot of times the judges kind of let some things fly, okay? But if you're going to be the one claiming that the other side is not following the rules, and you're not following the rules, well, then the judge is going to bring down the hammer like she's doing now. She's saying, okay, well, we're just going to live by your rules. And therefore, she's saying this is unacceptable. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. Okay, so if you do not, this is a strictly procedural bar. If you don't just follow the rules and the individual practices, we're not going to allow this motion to go on. I'm not going to decide it based on the substance of the motion. I'm just going to automatically deny it because you didn't follow the individual practices. And guess what? Sometimes I've heard lawyers say, especially when you have a big firm, how many lawyers do you have working for you? How much staff do you have working for you? Can't you put some staff on to figure out what the individual practices are or what the specific judge wants and the rules, and not just the court rules, and make sure that what you're doing is following the rules to the T? So I've seen that also. And she hasn't said specifically because they're a big firm, but she's saying that you better follow the individual practices. Lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of the court, see individual practices, the court discourages this approach. Okay, so you want to just, I'm going to file a Rule 11 motion and just file it with the court? Well, actually, you're supposed to request for leave. Now, even though she's saying technically you don't have to ask permission, leave is just asking. You don't technically have to ask permission to file a Rule 11, but in the individual practices, it still encourages you to seek leave of the court before you file a Rule 11 motion. Okay, again, like I said, Rule 11 motions are not a joking matter. No attorney takes that lightly. Okay, so this is what the judge is saying. As the court discourages this approach, if he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provision contained within Rule 11C2 from 21 days to 1 day. Meaning, if you want to file this Rule 11 motion and you want to have a hearing the next day and not the regular 21 days for the other side to be able to respond to your very strong and it's just a motion for sanctions, which no attorney likes, right? So you want them to have to respond in 1 day. That's not happening. That's not happening. Okay. First of all, you should seek leave, even if you don't see, and even if technically you don't seek leave and you intend to go on further forward with this motion, with this Rule 11 motion, well, it's still going to be 21 days. And guess what the judge is probably going to do if Alex Spiro actually files this motion? Okay. Let me tell you, if you're getting this and you're the attorney and you're reading this, you got to read between the lines. And if you read between the lines now, the judge is not quite happy with you. Okay. So if you think that she's going to grant your Rule 11 motion, you got to think twice. And unless there's something that she's completely unaware of, where you can just say, Your Honor, there's something that you just completely are unaware of, and then you're able to show her something which would substantiate your request of a Rule 11 motion, well, then maybe. But otherwise, she's kind of hinting here, don't file that motion, okay? It's not going to win. All right. Anyway, so here we go. Carter's motion to strike the amended complaint under Rule 12F is denied. By January 10th, 2025, plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. So remember, she did speak about that motion that was filed by Alex Spiro. So the preservation of evidence motion, that's going to go forward. So the plaintiff has to respond to that by January 10th. And by January 17th, 2025, Carter shall file his reply, if any. So if the plaintiff responds by January 10th, so then Spiro has till January 17th to file a reply. Well, here we go. The clerk of court is respectfully directed to terminate the motions at these ECF numbers. Okay, well, there you go. There you have it, signed by the judge, and a pretty scathing opinion, and not really appreciating the tactics, at least at this point, and the posture that Alex Spiro is taking. Now, is that going to change anything? Who knows? We'll see. Some attorneys like to stay aggressive the entire time, but the judge is kind of letting him know it's not really going to work in my courtroom. So maybe you should rethink about your tactics as it relates to this case. So we will see as this continues to play out, but a very interesting opinion there. If you haven't yet, please subscribe, like, and we will see you next time.